Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comments section below. It's free. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was accused of an attempted rape by my son's wife. Criminal attorney, Stockton. Attorney, Stockton. Attempted rape, Stockton. Accused of rape, Stockton. Let's see here. My son and his wife moved to live in my house. She sunbathes half nude in the patio. I have called her attention on the matter several times. Now, she has accused me of an attempted rape. First of all, let's talk about the charge. An attempted rape would be a violation of Penal Code Section 261/664. This is a felony that would carry up to 4 years in state prison, plus having to register as a sex offender for life. This is just a horrendous charge, and one of the main reasons is because there's not going to be any physical evidence. It's going to be a he said, she said type situation. So in this case, the police are going to have to interview the alleged victim to basically see how consistent her statements are, because this is going to be a case that's going to be purely circumstantial. Now, there may be situations where maybe this alleged victim may have told the confidant, hey, I'm going to make this story up because I'm pissed at so-and-so or whatnot. But if you don't have any of that to back up your version of events, it's just going to be her version of the story versus yours. And it's terrible. I personally do not believe that people should be convicted on simply the statement of the victim, but unfortunately these things happen. It's going to be necessary. And also, one more thing before I continue. Never, ever, ever speak to the police. I know you're thinking, well, I'm innocent, I have nothing to hide, it doesn't matter. You might say something that they can interpret as incriminatory, so it would be best if you simply remained silent. Remember your Miranda rights. You have the right to remain silent. Anything you say or do will be used against you in court, and you have the right to an attorney. Please, please, please exercise your Miranda rights. It's going to be necessary to go to court, enter pleas of not guilty, order copies of the police report and any other physical evidence that they might have, although they probably don't have physical evidence. The judge would have to give a new court to come back and start discussing the matter with the DA's office. Now, some of the evidence they might try to collect will be by way of a pretext phone call. Your daughter-in-law might call you and say, hey, John, I want to know why you attacked me, or I want to know why you approached me, or I want to know this or that. She might be saying this during just because she's being told to ask these specific questions by the police, who are in the background recording the conversation and listening in. So if you ever get a phone call from this person, just hang up on her, block her. You shouldn't have any contact with her anyway, because they could start saying that you're trying to intimidate the witness. So you have to be very, very careful with these things. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comments section below. But if you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677 here in the San Francisco Bay Area. On our next video, we're going to be discussing the case of somebody who's been having a sexual relationship with a minor of the same gender. Criminal attorney, Stockton. Accused of crime, Stockton. Attorney, Stockton. Rape charge, Stockton.